Title IX can force students out of public school a long time. By Michelle Ball, California student attorney and advocate since 1995. Receiving a sexual harassment complaint or sexual violence allegation can have significant consequences for students. For many years, Title IX, a federal law prohibiting sexual harassment and discrimination, was mainly used to punish college students. However, Title IX is now being used in public elementary, middle, and high schools. If a Title IX complaint is lodged against a public school student, that student may be held out of school even prior to the traditional school suspension or expulsion process beginning. This means a student exclusion may extend for a long time. What is Title IX? Title IX is a federal law which essentially protects students, and others, from sexual harassment and discrimination based on sex. Title IX is very broad and covers issues from discrimination in sports to inappropriate sexual touching, to stalking. Unwelcome sexual conduct, date rape, domestic violence, and sexual battery are also covered under Title IX. Examples of Title IX issues. Some student actions which could be reported under Title IX could be: a student touches another student's private parts without their consent. A student makes sexual jokes, teases, or takes other actions that create a hostile environment at school. A student sends sexual pictures. A student exposes themselves on campus. A student posts degrading sexual references about a student on a school group or chat. Sexual bullying, online or off. A student shares sexual items at school. A student grabs a student's bottom, thigh or body part. Sexual leering or vulgar gestures. Unwanted sexual acts. Use your imagination. Emergency removals under Title IX. Title IX allows emergency removals from school of students who are alleged to have sexually harassed another student. Federal law, the Code of Federal Regulations, 34 CFR 106.44, c, describes when an emergency removal of a student may occur under Title IX. The law states: emergency removal. Nothing precludes, prevents a recipient, school or school district that receives federal funds from removing a respondent, student complained about under Title IX, from the recipient's education program or activity on an emergency basis, provided that the recipient undertakes an individualized safety and risk analysis, determines that an immediate threat to the physical health or safety of any student, or other individual arising from the allegations of sexual harassment justifies removal, and provides the respondent with notice and an opportunity to challenge the decision immediately following the removal. This provision may not be construed to modify any rights under the Individuals with Disabilities Education Act, Section 504 of the Rehabilitation Act of 1973, or the Americans with Disabilities Act. So, per this section, the requirements for an emergency Title IX student removal from school are: 1. Allegation of sexual harassment. 2. Individual safety and risk analysis. 3. Determination an immediate threat to physical safety exists. 4. From the alleged sexual harassment. 5. Which justifies the student's removal. 6. Notice of decision to accused student. 7. Opportunity for accused student to challenge the emergency removal immediately after. 8. Disability rights of accused student remain. How long can a student be kept out of school under Title IX? It is unclear how long a public school student may be kept out of school on a Title IX emergency removal. Presumably an exclusion can continue until a resolution is reached, any Title IX process is complete, or the student wins an appeal. Return to a student's school and/or the student's prior school may depend on the investigation findings. After the Title IX process is concluded, the delayed California discipline process, for example school expulsion, can start, if cause exists. Of course, schools will then have a thick Title IX report to support their discipline actions. Sometimes, schools move the accused student to a different regular school in the school district and/or independent study, while the Title IX investigation proceeds. A student could also attend school outside a school district while the investigation is pending. A student conceivably could be out of school many months waiting for a Title IX plus school expulsion process to conclude. This may be great for the accuser and terrible for the accused. This is legal information, not legal advice, may not reflect current law and may not apply outside California, USA. No legal relationship is formed by watching this. Full disclaimers can be found at www.edlawforstudents.com/blog. Lawyer for Students, Michelle Ball, assists students facing Title IX allegations. As an attorney in Sacramento, California, she can potentially assist throughout the state, in Santa Monica, Loomis, Vallejo, Sonora, and many other California locales. Thanks for watching. If you found this video helpful, more are on the way. Subscribe now so you don't miss out.